How to monetize intellectual property. Video 2, Creating, Protecting, and Understanding Intellectual Property. Hello, Joel Douglas here. I am an instructor guest lecturer with the Shelby Colm Davis Professor of American Business and Economic Enterprise at Trinity College. Thank you for watching this series. This part of the series focuses on expanding your understanding of intellectual property and how it is created and protected. So now that we have described the basic intellectual property types in video 1, let's take a deeper dive into proven ways to create IP and protect its value, so that you have an idea that you think has commercial application and customers are willing to buy it. That's great, but ideas are notions. Converting ideas into real commercial products takes enormous effort, dedication, time, and money. The process of moving an idea from conception to reality is not mysterious or serendipitous. It is a deliberate product and business development process that needs to be followed in an orderly and sequential manner. The objective of this process is to protect the intellectual property rights of the invention, determine if the invention can be protected, and if so, how best to do it, and determine whether the invention is viable, has commercial value. To convert an idea into an invention with real product potential, you must take steps to develop the idea, protect the idea, and verify that the idea is worth spending your blood, sweat, and tears to develop. This is the hard work and a step often overlooked by the over-exuberant budding entrepreneur. So let's explore the 11 steps to accomplish this. Step 1. Once you have the initial product concept, you need to figure out if it is worth protecting. A lot of ideas look great at first glance, but as you peel back the layers of the onion, you either realize that the concept is too expensive for the marketplace, or that the potential customer either don't exist or they're unwilling to pay for the product. Perhaps because somebody else is already dominant in the marketplace, or competing with a product with fewer features at a very low cost. The first thing to do is to conduct a prior art search at the United States Patent and Trademark Office, the USPTO. The prior art search is due diligence to determine the originality or lack thereof of your idea. This is achieved by visiting the USPTO website. First select patents and then search the issued and granted patents links. Selecting Boolean search enables you to examine all the patents granted after 1995. Your initial search attempts typically return thousands of patents. Continue refining your search to reduce the number of resulting patents that meet your search criteria. Alternatively, you can hire a non-law firm to perform this prior art search for a fee typically around $300. The first-time inventor may benefit from professional guidance and expertise in their initial effort. After you're satisfied with the patents identified in your prior art search, you need to carefully review each patent. In addition, you also need to examine the search results for published patents that are not searchable by the USPTO search function, but can be reviewed from identifying them in the reference cited portions of the patents identified in your search. For example, pre-1995 patents are not searchable online, but if you locate a reference to them in the after 1995 patent database or publications, then you can view them online. Next, go back to the USPTO website and select patents and search the patent application database. You perform the same search you performed earlier, this time looking for valid prior art from published patent applications. This is important as the Patent Office published applications which have been filed approximately 18 months earlier. So you will see applications that may not have been allowed as patents or are still being prosecuted. This will establish a good basis for determining if there is insurmountable prior art in your area of your invention. If there is prior art, you need to evaluate the prior art to determine what actions or changes to your idea will be needed to avoid the prior art to give you a novel, patentable idea. This prior art search produces your initial patentability analysis, enabling you to revise your idea and, if possible, create a patentable product, ensuring that your idea has a strong likelihood of being patentable. Will greatly enhance your experience at the USPTO. You will eliminate a large number of prior art references that anticipate your invention and understand if your invention is obvious in light of the prior art. Let me share an example to illustrate this point. In this example, the USPTO eventually agreed with our patentability claim, but to get the patent, we had to modify the product so that it took advantage of steps that were not found in the prior art. Here's the example. I was working with a group of inventors who had developed a product for use in hospital intensive care units to modulate glycemic levels in critical care patients. After conducting an extensive search, it was clear that their product was not patentable. We brainstormed and carefully reviewed prior art to determine the processes that were either anticipated or obvious with respect to the prior art. Based on our analysis, we determined that if we added patient body temperature to the algorithm, it would create both a logical process and one that established a patentable process. We did this and were successful in our patent application process. I refer to two expressions regarding establishing novelty for invention and with it patentability. One is the anticipation and the second is obviousness. The most critical part of the patent law is defined by these two terms with respect to prior art patents. For prior art patent to anticipate an invention, the prior art must claim the same invention. For example, using a simple concept, you invented a means for crossing the roadway that encompasses the following 7 steps. 1. Standing on the sidewalk looking left for traffic coming from that direction. 2. Looking right for traffic coming from that direction. Repeating steps 1 and 2 until there is no traffic approaching from either direction. 4. Step from the sidewalk onto the road. 5. Walking across the road. 6. Stepping up onto the opposite sidewalk. And 7. Proceeding down the opposite sidewalk. Continuing our anticipated example, the USPTO patent examiner, while he was searching the prior art, finds the following patent to inventor Z, consisting of the following 5 steps. Standing on the sidewalk looking left for traffic coming from that direction. 2. Looking from the right for traffic coming from that direction. 3. Stepping from the sidewalk onto the road. 4. Walking across the road. 5. Stepping up onto the opposite sidewalk. Since the prior art does not include at least one critical step, in this case, steps 3 and 7 from the previous example, the prior art does not anticipate the invention. The concept of obviousness is made clearer using the following example. The USPTO patent examiner search locates the following patents issued to Mars, Jupiter, and Saturn. Mars has the steps of 1. Standing on the sidewalk looking left to determine if any cars or trucks are coming. 2. Looking right to determine if any cars or trucks are coming. Then stepping from the sidewalk onto the road, walking across the road, stepping up onto the opposite side of the road sidewalk. Jupiter discusses a means of not getting hit by oncoming traffic, comprising of 1. standing on the sidewalk, looking left to determine if any cars or trucks are coming in that direction. 2, looking right to determine if any cars or trucks are coming in that direction. And 3, repeating steps 1 and 2 until there are no cars or trucks coming in either direction. Saturn is a pattern for moving to a location on an opposite side of the road comprising of the following steps. 1, standing on the side and walking across the road. 2, stepping up onto the opposite side of the road sidewalk. 3, walking on the opposite side of the road sidewalk. Looking at the teaching of Mars, Jupiter, and Saturn, it would be obvious that combining the teaching of all 3 patterns will result in a better process, and it is your basic process described in your invention. However, because the process described in Mars, Jupiter, and Saturn are already known to the public, you are not entitled to a patent because the invention is obvious. A way to get around this obstacle may be to modify steps 1 through 3 using an innovation such as a portable drone controlled by your mobile phone to look in both directions prior to stepping out into the road. But this may be found to be obvious if another pattern were identified, also using a drone to examine oncoming traffic. I think you get the idea that you have to be creative to get a patent, and that means both the inventive process and the method of working around the prior art, already part of the public knowledge. After you have satisfied yourself that your idea is novel, the invention with a strong likelihood of receiving a patent, you must perform market research to determine if there is a viable market for your product and customers willing to buy it. You need unbiased opinions from an independent group of people, representative of your potential customers. Organizing 1 or more focus groups, a small number of people, typically 8, brought together with a moderator to examine and discuss your proposed product, is an excellent way to test your product's marketability, usability, acceptance, and other features. Focus group participants shouldn't have prior knowledge of your product, shouldn't be friends or family members, must sign non-disclosure agreements and agree to the terms of participating in the group. Their detailed feedback is essential to completely understanding the problem your product is intended to solve and establishing a price customers are willing to pay. The requirement for non-disclosure agreements with focus group members is driven by the mandate to protect your future intellectual property rights. Current United States law governing the issuance of patents is referred to as the American Invents Act. This act limits the time to apply for a patent after a disclosure by the inventor, unless it is conducted under an agreement not to disclose. Those same laws also stipulate that if you have public use or sale of the product, then you can lose your intellectual property rights. So you must be very cautious regarding any disclosure and never under any circumstance display or offer to sell the product into the public until you have filed your patent application. Thank you for watching, and I look forward to seeing you again for the 3rd video entitled Proven Ways to Create and Protect Intellectual Property, Steps 2 through 4.